Thank you, Madam Deputy Speaker, and may I begin by saying what a pleasure it is to follow the member for Brent North. I'm going to develop a number of points through my submissions, but I do think that actually it is important to say that in a number of regards, when I was listening to his speech, I found myself nodding along. He knows that I care about this issue as an MP because it's affected constituents of mine in Berkshire who were employed by BA and Centrica, and I care about it from a technical, legal perspective as an employment barrister. There are a number of points on which I think we can all agree on both sides of the House. It is unacceptable for employers to use fire and rehire as a pretext to force through long-standing changes to the workplace at a time when workers are vulnerable and they're less able to mount a challenge. We all agree that we saw some of that last year, and I think we all agree that there is scope to tackle the issue. Where I think we disagree is on how we do that. And I'd just like to pick up on where my honourable friend left off. One of the things that we don't do enough in this House is acknowledge that there is room for a legitimate difference of opinion on legal solutions. In fact, even outside the political domain, we know that there is a divergence of views on how to address fire and rehire, because when BEIS commissioned its call for evidence through ACAS earlier this year, one of the most striking features was how all the people who contributed to it did not agree themselves on how best to resolve the issue. So what comment I have to make on this bill will be understood and interpreted, I hope, in that context. My view is one that is shared by other legal practitioners, and I will develop these points. I know there's going to be an interruption quite shortly, but I maintain a view that this bill actually poses risk for workers' rights. And I also think that it exacerbates one of the deepest problems that in industrial relations that has come about through this practice. But I think the wider point I want to make is that any opposition to this bill today is not a Tory thing. It's not the Tory party against the Labour Party. There is a body of professional legal opinion of mixed political persuasion who hold the same concerns that I do, and I do want to say that I am grateful to the Minister, to the Secretary of State, to all their officials for the way that they've engaged with me with my own proposals, and I can tell from the serious scrutiny that they've applied, that the questions they've lobbed back at me throughout the summer, that they're thinking carefully about this and that there is scope to address this issue. One of the things that hasn't been acknowledged, I don't think by any member of the opposition and not by the honourable member in his opening speech, is that there is already some protection at common law against this practice. And I think it is important to spend a moment looking at what the common law says, because you can't sensibly say where the law is going wrong until you've had a proper look at where the tribunals might be failing. So, when the issue was first considered by the Employment Appeal Tribunal in 1990, they said, you simply cannot hold a pistol to someone's head and say, henceforth, you're to be employed on wholly different terms and remunerated at 50% of your previous contract. We come unhesitatingly to the conclusion that when that happens, there has been a dismissal. In what circumstances would an employment tribunal find that dismissal to be fair? First of all, the employer must show that they have a substantial reason for that practice within the meaning of Section 98(1)(b) of the Employment Rights Act. That's usually interpreted as sound, genuine business reasons, and also that they have acted reasonably in accordance with equity and the substantial merits of the case within the meaning of Section 98(4). For any employer to meet those thresholds, they will have to go to the tribunal and show, firstly, that there is a genuine necessity for the changes, that the changes are not there just to swell shareholder dividends, but are there to lead to a determinable advantage to the performance of the business. And the second is the reasonableness test, which is really a proportionality exercise. I refreshed my memory yesterday to the well-known case of Garside and Laycock, which was an appeal court decision. I'm just going to finish the anecdote and then I will take your intervention in a second, which was the last significant appeal court decision I could find on fire and rehire 10 years ago. And in that case, the employee brought a claim for unfair dismissal because he wouldn't accept a reduction in his wages. What questions did the appeal court ask themselves? First of all, they asked, why had the employer done it? Was it in genuine economic difficulty? The answer to that question was yes. What was the size of the cut that they were asking the employee to take? It was 5% of wages. Had there been a proper consultation with the staff? The answer to that question was yes. Had they balloted the staff? The answer to that question was yes. Had those who'd participated in the ballot agreed to the cut? Everybody apart from this employee had agreed, and in those circumstances, his dismissal was fair. That is an important yardstick to have in mind in considering whether we need primary legislation to deal with this point. So why is there an issue? And I know honourable members across the House continue to believe that there is an issue. Well, I think that the answer actually was captured very well in one solicitor's evidence to ACAS, and I'm just going to quote it because I enjoyed reading that report. From an employer perspective, so long as you followed the consultation, you will probably be okay. If it gets to tribunal, no judge looks very closely behind the reasons why an employer is doing it. It's all about the procedure. They don't necessarily ask all the same questions. So in that respect, an employee is not perhaps so well protected. And it is a fair observation, I think, and I mean this with no disrespect to employment tribunal judges, but some of them have not previously run their own businesses. They don't have the direct experience, and they're not always best placed to test the strength of the employer's explanation. I will give way.
I thank the Honourable Member for Newbury for giving way. Clearly the status quo is not sufficient, hence the need for my Honourable Member's bill, which many across the House support. This is the way we resolve it. Today I should have gone to a funeral of my good friend Tony Murphy. He believed in fairness, in doing the right thing. Last conversation I had with him not very long ago, the Bull's Head pub in Frodsham, we spoke about workplace bullying and the need for fairness. Come on, do the right thing. Support the Honourable Member's bill.
Well, I thank the Honourable Gentleman for his intervention, and I am still at a fairly early stage in what I have to say. I think his point about fairness is really, really important, and I hope the solution that I've come up with, which is not dissimilar to my honourable friends, meets that threshold. Yeah, we'll give way.
To the honourable lady for giving way. Before I came into the House, I used to have patients who came to me who were under the threat of being fired. And I think that, for me, seems to be the issue here, is that pending threat. I'd be interested to know how many times this has actually gone through with, and interestingly, whether or not you feel my honourable friend feels the legislation that either put forward from the opposition or indeed herself will deal with the actual threat, not necessarily the outcome.
I'm very grateful to my honourable friend for that question, actually, because that's going to actually inform some of what I have to say about Clause 1 of this bill and about the consultation obligations that you are seeking, sorry, my honourable friend is seeking to set. Because I actually think one of the things, I can see we're going to stop quite shortly, so I'm not sure if I might be getting to a point where that would be appropriate. But I'll just say this. One of the things that I think has been particularly striking with the constituents that I've engaged with is the fact that Fire and Rehire was mentioned in their very first consultation meeting. So from the get-go, they didn't feel they had any reasonable opportunity to renegotiate their employment terms and conditions because they always felt they had the sword of Damocles hanging over their heads and the possibility that they were going to be dismissed in the alternative.
Way, she will know that the context in which we're having this debate as well, at a time of great economic uncertainty, there are thousands of aviation workers as well in my constituency, whether that's been through Heathrow Airport or BA, Donata Catering or others, who have been affected by this. Thousands of them are living on reduced incomes, up to £8,000 a year, having that massive impact. Other employers behave differently. Has she done an assessment of her proposals to come to a view about whether that kind of practice that's impacted my constituents and hers and others will be prevented by the proposals that she wants to bring forward.
I'm grateful to the Honourable Lady for that intervention. I considered the aviation sector specifically when coming up with my proposals, and in fact they were probably the leading sector that I had in mind, although not the only one when considering an alternative route through this, and I will develop that point too. So the question, I think, actually is, why should we not simply pursue the course of action in Section 27C, or the new Section 27C as proposed for the Employment Rights Act under Clause 2 of this bill? And I have to separate, I think, from the Honourable Gentleman and say my concern is, despite what he said about this, I think it will have the practical effect of banning fire and rehire, and I want to say why.
Exactly right.
First of all, one of the things, again, that came through very strongly from the call for evidence that ACAS published is a tension, an inherent tension that exists between the trade unions and the employer. And that is that trade unions wish to see evidence that the business is visibly failing before they're willing to accept any reduction in terms. And the business wishes to remedy the defect before they are on the brink of collapse. The concern that I have in that regard stems from Section 187B, as proposed for the Trade Union and Labour Relations Act, which says, and I'll just quote briefly, the information to be disclosed by the employer is all the information relating to the employer's undertaking which is in the employer's possession, without which the appropriate representatives would be to a material extent impeded in carrying on consultation with the employer, which it would be in accordance with good industrial relations practice that the employer should disclose. You can see from me reading it how wide it is. There would be almost no circumstance when an employer, I'll just take a moment because I only have seconds till we break, but there would be almost no circumstance where an employee would not be in a position to say, oh, the employer didn't consult, they didn't show me this, they didn't show me that. And employers would be genuine risk of being dragged into the employment tribunals on every occasion. I think I concluded by going through what I thought was the breadth of the proposed new Section 187B, and how I think, very respectfully, that it creates considerable scope for any employee who's faced with a fire and rehire type situation to challenge through the employment tribunal. And may I make this observation? It creates, I think, an obvious and unsustainable tension with common law principles. I'll just finish this point. That the common law principles that underpin the entire law of redundancy. You could have circumstances in which an employer has made the decision to reduce the terms of employment, to reduce wages, in circumstances where an employment tribunal, applying every single correct common law principle, would find the dismissal or the decision to have been fair, and yet, because they had breached one element of the consultation requirements, they hadn't put one document or one meeting note before the trade union representative, that dismissal would be found unfair. And I think another really important point is to look at the way that the bill... I will give way.
I'm grateful to the Honourable Lady. I've listened very carefully and I'm very respectful of her knowledge on this particular issue, but there's nothing that she's put forward today that suggests to me that her arguments can't be better deployed in the committee stage of this bill. And my honourable friend asked for members of the government benches to work with him to improve this bill in committee. So I wonder why she's not taking that approach.
Good point.
Thank you very much to the honourable gentleman for his intervention, and I will continue with developing this point. The other thing that I can't, which I hope will answer his criticism, the other point which I can't ignore, and I invite every member sitting in this House to turn to it, proposed Section 187F, the proposed award of compensation made by any employer who fails to comply with the proposed new consultation requirements. The amount of compensation awarded shall, subject to the following provisions, be such as the Employment Tribunal considers just and equitable in all the circumstances. That is exactly the same compensation measure that is used in whistleblowing, in discrimination law. It opens the door to uncapped compensation in the area of unfair dismissal, which has a cap, and therefore it drives a coach and horses through the entire principle of compensation in unfair dismissal hearings. It would make fire and rehire the only form of unfair dismissal where the employee could get an uncapped compensatory award, where if they'd been dismissed for gross misconduct or if they'd been dismissed for being bad at their jobs, they'd have been capped at 80 grand. That cannot be right. And so what will all of this do to the employer who's thinking about renegotiating terms of employment? They'll be too nervous to do it. And what they'll do is they'll lay off. So take the employer, for example, in the case of Garside and Laycock, considered by the appeal courts, who had proposed a 5% reduction in wages, which every single balloted member of staff, except for one, had accepted. They wouldn't do that. They would lay off the whole workforce. Is it better or worse for people to take a less attractive variation to their terms of employment, or that they lose their job altogether? I will give way.
I'm grateful to the Honourable Lady for engaging so closely with the bill. I think she knows that in her last remark she is over-egging it, because any tribunal would look at the situation in the round, but also the reason that it is stated as it is on the bill is because, of course, it also chimes with the legislation on redundancy. So, again, in order to make the bill technically proficient, she would know that it has to merge with the other acts.
I'm afraid the Honourable Gentleman is incorrect on that. That was a concern that was raised by my head of chambers and is shared across the employment bar. You cannot have a just and equitable jurisdiction in the law of unfair dismissal. It doesn't work. And I want to pick up on the point that the Honourable Member for Feltham made very well about the aviation sector. When we start looking at... I've got some more to say about British Airways because I think that their conduct was poor. But there is an important issue at stake here. If it was the case that in primary legislation the risks of fire and rehire were so great that employers were more inclined to lay off, think about what that would mean, for example, for airline pilots, where they must fly within a 2-year period to retain their flying licence. If they're sacked from British Airways at a time when the entire travel sector is struggling badly, they are very unlikely to get a job. It could easily be 2 years. It's not just the loss of a job, it's the loss of an entire career. And I think we need to tread very, very carefully when we look at primary legislation in the area of fire and rehire. Yes, I will give way.
I'm very grateful. She's making an excellent speech. She's making some very important points. She talks about the risks of this situation moving into a layoff situation or redundancies or whatever. Is there also a danger here that businesses don't start up and recruit people in the first place or don't scale up because of the fear that because employment legislation is so complex and increasingly one-sided on behalf of the worker, that will deter employment, which is exactly the opposite of the situation that we all want to see.
Well, I thank my honourable friend for that point. Of course, we all know in this House it's always a risk where you make employment relations so onerous that there can be a temptation to engage consultants. I think what we're primarily looking at here are employers who have larger unionised workforces, so I'm not sure how much that would engage. But I think the short point is that we want a solution on this side of the House that does not make an existing problem worse, that does not drive redundancies or lead to more business failures. And I think, in my view, fire and rehire must be a genuine option of last resort when a negotiated settlement cannot be reached, the business is on the brink of insolvency, and the alternative would be layoff. And yes, I will give way.
I thank the member very much for giving way, and I'm also very grateful to her for the conversations we had when I brought forward legislation last year on this. But she mentioned if it had been banned, British Airways may have just made people redundant, and she gave the example of the pilots. But it was already brought up already. Ryanair made negotiated temporary changes. Why wouldn't British Airways have done the same had they not been allowed to follow the fire and rehire path?
Well, I think I'll return to that point when I come to British Airways in a bit more detail, but I think it's probably time to say what I think we need to do in this House. And I do think, and I have said this to the Minister, we need more than ACAS guidance. What I want to see are the rules on dismissal and re-engagement set out in an ACAS code of practice with financial sanctions to back them up, and I'd like to set out why. First of all, when Parliament passed the Trade Union and Labour Relations Consolidation Act in 1992, it specifically envisaged the possibility of doing this. Section 207 gives the Secretary of State a power to introduce a code of practice in respect of any of that bill. Parliament also considered and welcomed the possibility that the Secretary of State would have the power to impose some legal teeth for that. Section 207A, the possibility that if the employer doesn't comply with an ACAS code of practice, they can have an increase in the amount of any compensation of up to 25%. We also know that ACAS codes of practice can be effective. I know the Honourable Member for Middlesbrough is an employment lawyer, and he will know when we think about, for example, the ACAS code of practice on disciplinaries or in relation to grievance procedures, it is vanishingly rare to get into the employment tribunal nowadays and find the employer who was oblivious to those codes of practice. Why do they know about them? Because there's risk, there's financial risk. If they go down in the employment tribunal, there could be an uplift on compensation, and they want to avoid that. So we know that it has the right effect. What should the code of practice say? Well, we have some of the answers already. The Bayes call for evidence that was published through ACAS gives us some of the clues which I think practitioners made very well. Paragraph 56 of that report, that employers should provide an analysis of whether changes are anticipated to last for more or less than 5 years with evidence to substantiate their answer. Paragraph 76 of that report, evidence of reasonable alternatives that they have explored, evidence of their financial position, and also, and I think this comes out of the excellent work that was done by the Transport Select Committee, and I want to pay tribute to the very impressive session that they had with Willie Walsh on the 7th of May last year. And you will recall, anyone who's read that transcript, he was asked repeatedly by the chair of the Select Committee, if British Airways returns to full profitability, will you restore workers' wages to their previous levels? And he declined to confirm that he would do so. I mean, that created huge exposure for British Airways, and I don't think it's any surprise that when Alex Cruz appeared before the Select Committee 6 months later, he gave a rather different explanation. But Bayes would have the opportunity then to require employers to set the criteria that they would exercise in deciding when to restore workers' pay. And I think that it would enable the government to give guidance on this distinct category of dismissals, how they should be treated and what the employment should be looking for. And finally, my final point on this is it would give the government real teeth, and it would incentivise employers to do the right thing and give employees more power to enforce their existing rights. The point's been made. Most of the employers that we've cited in this House are considering fire and rehire to large proportions of their workforce. With British Airways, I think it was 12,000 people who were at risk. If every single one of those people could get an uplift in a compensatory award of 10 to 25%, let's be realistic, that might be £10,000, £20,000, times 12,000, that creates a huge incentive for the employer to do the right thing, because there will be a very significant financial penalty if they fail. That will mean that consultations are entered into with legal advice, which is a good thing, with an open mind and an open spirit. And by the way, consultation isn't a meaningless word, as you will all know. When it's approached in the right spirit, it can often lead to alternatives to the thing that is most feared by the employee. So that is the suggestion that I've made to ministers, and I will give way.
I was one of the members on that Transport Select Committee, and mainly there was a very cross-party agreement that it was such a disgrace that happened that company shouldn't have even carried the British flag. But the point is, the parent company IAG had profits in the region of maybe £3.5+ billion, but were there in status that they could have used. And so actually the agenda that was in play, and this is why I'm concerned that what you're suggesting may not go as far as in discouraging people, is the fact that IAG were driving that about their profits, and it was not about saving the jobs of those and livelihoods of people, particularly women in their 50s towards the end of their career. So it was a restructure brought under the guise of fire and rehire.
That's an excellent point made by the member for Ilford South, and I just want to pick up on what he said. He points to the fact that the parent company had substantial profits. That point was made by Unite representatives who contacted me. I don't think that case would have survived the employment tribunal in its early stages. I don't think they'd have crossed the threshold of a sound, genuine business reason. And I think that the reason that Alex Cruz appeared before you 5 or 6 months later and spoke very differently for his plans for pilots and cabin crew and everybody else was because they were on thin ice, and I think there were some damaging concessions that were made in that session. So I think you're right, but I don't think that my solution fails to capture it.
The Honourable Lady, not to use the word that's right.
But I don't think that my proposal is at odds with what he suggests. Just briefly, actually, I'm coming to the end. I'd like to focus the remainder.
Keep going.
I'd like to focus the remainder of my remarks actually on the detailed work that's gone into Clause 1 of this bill and the extended duty to consult, which I think it is proposed would go into the Trade Union and Labour Relations Consolidation Act at the new 187. And one of the things that I think is most surprising about this, despite obviously it's very persuasive at first blush, but it immediately takes both the trade union and the employee and the employer into their very first meeting talking about fire and rehire. And when I spoke to my constituents and when I spoke to the Unite representatives who were looking after them, the thing that had been the most stressful is that they'd gone into these meetings and found that from the very start already dismissal was being mentioned as an option. It is, you will take this pay cut, otherwise we'll sack you and get you back. And this seems to exacerbate that problem rather than than improve it. I think that what we need to do, actually, I think that the law at the moment in this area is not working, because when I speak to employers about why they've been raising fire and rehire so early, they've always cited Section 188 consultation obligations, the in good time requirement under Section 188, and the genuine fear that they'll be hit with a punitive protective award if they haven't put all their cards on the table at the start. And actually, I think a much more sensible view would be to take the heat out of these negotiations. In fact, make fire and rehire a last resort that only comes in when all other options have been explored. That's why I think we should have specific language in a code of practice. It should say something, for example, that an employer who begins a Section 188 consultation only after it has attempted to negotiate a change in terms and conditions consensually will be regarded as beginning that consultation in good time. Or, alternatively, say that where an employer is attempting to negotiate new terms and conditions before any fire and rehire process, that amounts to special circumstances which rendered it not reasonably practicable not to comply with Section 188. Yes, I will give way.
I'm very grateful to the member of Newbury who's making some very interesting points. But would she agree that, given that she agrees with the spirit of the bill before us, that there should be last resort fire and rehire, and we should look at this in detail as she is now, this would be better looked at committee stage of this bill? And why wouldn't she? Because obviously we appreciate this is complicated and she's a great expert in this and we appreciate that. But wouldn't it be better for her to be forensically evaluating this bill with good time with Barry and others at committee and agree this?
I thank the honourable gentleman for his intervention, and I know the honourable lady wanted to intervene as well, so I will give way if she'd like to.
What did she say?
I thank the honourable lady. She is making some excellent points, which, like my honourable colleague, I felt might be better made at committee stage. But would she agree that part of the motivation for this bill is not to do away completely? It is actually does say that fire and rehire or change of contracts in exceptional circumstances can be done with negotiations, consultations, etc. But the motivation was that several companies, major companies, appeared to be using the current crisis as a way of hiding behind that to institute unfair fire and rehire practices at a time of already mounting stress and emotional trauma for a lot of people.
I will.
I just wish to...
Lady needs to answer the first intervention before having a second intervention.
Thank you, Madam Deputy Speaker, and I'll take those 2 points in succession. The first point is this not better for committee? The answer very respectfully is no, because I do not think an area as technically difficult as this belongs in primary legislation, and I've explained why I think it's at odds with the Trade Union and Labour Relations Consolidation Act. It's at odds with the intention of Parliament when that Act was passed. It's at odds with the existing web of laws at Section 98 dealing with unfair dismissal, and I think it belongs in a code of practice that's backed up with financial penalties rather than in primary legislation. To take the honourable lady's point, of course I accept the stress that people were subjected to, and all the work that we're doing on this side of the House is directed at minimising that. But I don't think the solution that we're considering and discussing is sort of giving employers leeway to abuse employment rights, and that's something that we've been thinking about just as much. Yes. So it is really precisely because I don't think that employees should have a gun to their head at the start of consultations that I can't support Clause 1 of this bill, which requires employers to lay all their cards on the table on the issue of fire and rehire from the start. And I also think, just to finish my point, rather than demanding full disclosure from day one, we should be much more sensitive to the legitimate desires of business to remedy defects before they have to reveal that they're on the verge of failure, and what that might mean for their business at a stage before they would wish to disclose it. I will give way.
I'm very grateful to the Honourable Lady. I absolutely agree with her that taking the heat out of this at the very beginning is really important. And she's absolutely right, and indeed I mentioned it myself, about the importance of not having the Section 188 immediately on the table. That's why if she looks at line 20 of the bill, it says the employer shall consult with a view to reaching an agreement to avoid decisions being taken to terminate contracts of employment or to introduce changes in work organisation or in contractual relations. Precisely the point that she's made is there in the face of the bill.
But the Honourable Gentleman will also know that Clause 187B, subsection 2, also says the information to be disclosed is all information relating to the employer's undertaking. It would be almost impossible for an employer to comply with that without having to put on the table that they're considering dismissal in the first instance. But, Madam Deputy Speaker, if this speech has strayed into technical issues of industrial relations law, I hope that reveals actually how difficult this question is, how any attempt to impose primary legislation runs significant risks of unintended consequences that will be much worse for workers' rights and for job losses. We on this side of the House perhaps depart from you in that we think there is strength and flexibility in existing employment law, but we also think that it could do with being robustly reinforced through potential financial penalties. And I hope my honourable friend is reassured that we take this issue as seriously as you do. We are also thinking hard, and I am confident that we will deliver for workers' rights. Shadow